So it's a fine line if they give you an example, but if the person is dealing with a business decision, that's the key thing in the wording, then it's a business ethics problem. Ethical dilemma deals with the problem where it's not always clear and there's not a right answer. So that's the ethical dilemma. And for example, the person that was going to hire, the hypothetical we looked at where this person had been in prison and he was applying for the job and he was the best available candidate for the job. And so the hiring officer had an ethical dilemma. Should I hire this person because he's the best candidate for the job? But on the other hand, he has this past criminal problem. So that's the kind of thing. They might give you one of those in the short answers. The short answer also is going to give you something like this. As short answers. They might ask you the WPH process, making decisions. So it's also the kind of multiple choice questions that they give in the past. This is where they ask you which of the two choices below are the stakeholders under the who. So WPH is especially the who. Know what they mean. Who are the stakeholders? So you always think of the consumer. You might think of management, the owners, employees, but you don't forget the community and future generations. Customers and unborn children. And the P, remember, is the values. What's the purpose? And so this whole idea is, this is like a list. It's a list of things you should have in front of you when you want to put together like a corporate conduct rules. And one of the reasons to have this is to give people freedom, because employees will feel better about their job. They'll feel better that they're protected. It gives them security, knowing that if they see something bad, they will report it and they will not get fired. Not every company is like this. I'm not saying this is the perfect world. We don't live in a perfect world. But in a perfect world, we would want to be protective. You're an employee. You see something bad, you should report it to the higher-ups, and you will not lose your job. Justice means that you will see fairness. If somebody who does something bad gets punished, and as it should be, and efficiency. Everybody works on their job better if they know they're protected. That's the idea. So it's a practical application of ethics. It makes sense. Like I said, this is the perfect world. And we don't live in a perfect world, but this is what they're trying to shoot for. And how? How do you do it? Well, first you got to publish the rules. You got to let everybody know, not just inside the company, but outside. Second, universalization. Everybody is involved. It applies to everyone, whether you're the top person or at the bottom of the ladder as an employee. And then the golden rule is the how. It's to try and treat everybody the same. The golden rule, everybody is treated the same. Okay. So, chapter 2, I don't think there's going to be too much. It's going to be focused on true and false, like I said, definitions. What's the W stand for? Includes the following. That's what they're going to say in the true or false. The under W, the following types of person is included, true or false. That's the way they're going to put it. Under W, the community is one of the stakeholders, true or false. So now we move to chapter 2, and there's going to be some of this, and this is going to be multiple choice of true or false. The difference between these two, you got to know this, original versus appellate. You're going to lose a point if you don't know this. They're going to ask you, the definition is the power to hear and decide cases. When they first enter, remember first, that's what it's going to be. It's original. An appellate will be the other. So if you know your original, then you'll know appellate. The power to review previous. So just remember those two words. First means the first one, original. Previous means appellate. Those are the key words. We'll tell you then what they're talking about. So what they do is mix it up. They're going to mix it up. They're going to say original jurisdiction is the power to review previous. That's the way they're going to mix it up. So you can't be tricked by that. If you know first and previous. And then two types of jurisdiction. So there isn't just one type. There's multiple. We look at this, it's like a ladder. The first step, we talk about original versus appellate. The second step in the ladder, then we talk about in personam versus subject matter. In personam means that the court, where you first enter the court has to have the power to give you a decision over specific persons. So, if you are trying to sue someone and he is not in court because you have not served that person, then how can the court give you what you want, right? Doesn't have a rights over the person that you need, that you're suing, has got to be in court. It's got to be standing next to you in front of the judge. That's in personam. So if you don't serve someone properly, we talked about that, and that's going to be part of the question, I think, then that person is not going to be in court, and that person is not, cannot be sued. So in personam means that both people have to be under the power of the court. So when we speak of in personam, you're filing the lawsuit, right? You're already in court. It's not a problem with you, the plaintiff, because you are filing the lawsuit. But the court also has to have the power over you. So you got to be the right type of person. Okay? You can't, if you're suing in federal court, you have to, as we're going to look at it, that's another type of jurisdiction. You got to be part of, under a federal lawsuit, federal question. But let's not complicate it for now. It just means that you have to have, the court has to have the power over the people in front of the persons. The other kind, what's called subject matter, is there's only certain kinds of courts, specialty courts, that deal with special problems. So you can't go into a regular court. You have to go to a special court to solve your problem. For example, this is, if you have a federal case and there is specific ways to get into federal court. One is subject matter. So subject matter means that you have to go to a federal court if you have any of these problems. So they might ask you, this is a multiple choice question type. where they will ask you 2 or 3 of these. They'll name them. And then they'll name a 4th one that's not on this list. And then they'll ask you which one of these is not subject matter. They'll reverse it on you. The other way this can be brought up is short question, short answer. They will ask you, name 2 types of subject matter jurisdiction. Subject matter. So always remember the sea. The sea, the waters, Admiralty, the water. And think of the bankrupt sailor. I'm giving you some. Think of the bankrupt sailor who goes in the sea and comes home and he's bankrupt. So the sailor is on the sea, Admiralty case, and he's bankrupt. He's poor. He hasn't been paid. And by the way, he stole something in another country. So think of a bad sailor, and he's been drinking. This is what we call the drunk sailor. So he was spending too much money and too much drinking, and he went bankrupt. And so you have federal criminal prosecution, bankruptcy, and Admiralty. Just think of a way to remember these. Then I'm going to give you the one on the bottom because that's very vague. But patents, if you want to have a federal patent case or claim, if you want to sue the United States government, when one state sues the other, they're not going to ask you that. That's too complicated. Just remember Admiralty, the drunk sailor who committed a crime. He touches upon Admiralty, bankruptcy, and federal crime. Okay, subject matter. Jurisdiction. It means, again, we can have both state and federal subject matter jurisdiction. This is where, in some cases, so we talked about subject matter for federal only. This is only federal. Okay. But we also have subject matter where both the state and federal government courts share jurisdiction. Remember, jurisdiction is the power to hear a case. So in some cases, in some situations, you can go either to federal court or to state court. You as a citizen of Saudi Arabia owns a company and you want to bring a lawsuit in California against a technology company that stole your ideas. Say you hired someone and in Saudi Arabia to do some software, and then he gets a visa to come to the United States, and he steals your ideas and he sells them to his new employer in the Silicon Valley. So where are you going to sue? You're going to sue this person and the company for infringement of your intellectual property. You can go to federal court, like a patent, or you can sue him for damages. You can sue in a lot of ways, but let's say you don't have a patent, but you want to sue him because, and his employer, new employer, because they stole your ideas. So you go to federal court and sue both of them in San Jose, California. Or you can go to the state court and sue them for both federal and state causes. That is, that there's a state law that says, and there is a state law that if you steal from another, you have theft. This is major theft that's worth millions of dollars. You can sue for that and get money, or in federal court. You don't have to go to federal, you can go to state, or you can go, either one. And the reason you can get into federal court is because you are from another country. So you're suing people who are You're the plaintiff. You come from a different state or different nation, and you're suing someone who's in California, a resident in California. Now, you would sue the company because in diversity, the parties cannot be from the same place. Okay? So, he is from Saudi Arabia. He's a citizen of Saudi Arabia, and you're a citizen of Saudi Arabia. You see, so that would block you from going to federal court. But what you do is don't sue the individual, you sue his employer. Because his employer is the one that's paying him and making the money. Your ex-employee may not have a whole lot of money. He's on a visa, doesn't have money, but his employer does. And the amount at stake has to be over $75,000. Now, there's two ways. Also, that's the major way. So you have to know this. $75,000. They're going to say $74,000. They're going to say $76,000. They're going to say $77,000. So you have to know that by memory. $75,000. And they have to be from different states. The parties have to be from different states in the United States. They won't give you an international one. They'll say, well, one person's from California, the other's from New York. That's okay. So a federal question means that you can sue someone in federal court if you're suing under a federal, U.S. federal law. And that's a patent. That's international. It's a patent that you're suing, or intellectual property, or theft, interstate theft. That is from one state to another, or one country to another. You would sue there in federal court because it comes under a federal question. So what I'm saying is that kind of situation, you can go under both. This is a short essay question or even a long essay question. The essay question will start off with somebody bringing a lawsuit, and then he has to sue the person properly. So remember where you have to knock on a door 3 times, a hypothetical, where somebody doesn't open the door to the sheriff. The sheriff has to deliver papers. So when you go to court, you have to deliver papers first to the other side that you're suing. Federal court system in the state is the same. They just call different courts, but let me go back. They just call U.S. Supreme Court. California has Supreme Court. California has Court of Appeals. It's really called the Court of Appeals. In your question, it might say intermediate, but it's really, we don't say that, we just say Court of Appeal. And the trial court is where you start your case. These are called U.S. District Courts. They're not going to ask you about the state court system because there's 50 states, and you don't have to know the law of 50 states. Some states are different. California is exactly like this structure, 3 levels. We're at 3 levels. The trial court can only accept evidence. Remember that. When you start your case, that's where you speak up. That's where you present your documentary evidence or anything else. Once you get to the appeals, you cannot submit any more evidence. You cannot submit any new evidence at that level. What they do is look at the court record. They look at what was permitted or not permitted to be entered, and that's how they make their decision. So to get started, we talked about different jurisdictions, right? Even before you get there, you are trying to decide if you can bring a lawsuit. Somebody has taken money, has tricked you, committed fraud against you. So the first thing you have to say is, can I sue him, that person? In other words, you have standing. Standing means that you were injured. You have to show injury, either physical injury, like somebody, you're a pedestrian and you're hit by a moving car, or economic damage. And you can also suffer mental damage, mental hardship. You have to suffer injury of some sort. That's the first step. The second step is, what if the other side said, you don't have to sue me, I will settle for any amount you want, but you nevertheless bring the case to court. Maybe you need to say you want more than was offered. In other words, you did not settle the case. There has to be a controversy, a case. So if you settle, you can't sue. You can't settle a case and then sue before you go to court. Think of it that way. If you settle with someone, then that ends your right to sue that person. The next thing is ripeness. Ripeness means it's the trickiest. It's got to be the lawsuit. You not only have to have standing, and there has to be a controversy, but it's got to be ripe. It's got to be ready to take to court. So, let's say that you were hit by a moving car, but you have to see doctors, many doctors. And so some doctors are saying, well, you didn't get really badly injured. Other doctors are saying, yes, you did. And you're trying to sort out, is it ready for me to take to prove? What do I need to prove my case? And so you have to see more doctors, more specialists. Another thing could be, let's say you gave somebody 30 days to pay you. You give them a note. But he gives you a note, you give him $10,000 US dollars. He says, I'll pay you, say, in 6 months. And now it's 5 months. And you believe that that person's not going to pay you. 5 months, and you have one more month. You talk to him, and he says, well, I don't have enough money to pay you on time, and whatever. So at that point, you cannot bring a lawsuit because the other side has not defaulted on the note. It's got 30 more days. That's what ripeness means, as an example. It's not ready for a lawsuit. This is the way that a court will look at the appeals level. It's either, these are the choices that the court has. Affirm the decision from the court below. It says, we agree with the judge. Or modify. They can change the opinion, the judgment. Maybe the judge gave them too much money. It was too much. We're going to change the amount. Reversal means that the case is thrown back to the lower court, the trial court, because the judge made a big mistake or something. So it's reversed completely, 100%. And then remand. So the reversal, by the way, the judgment from the court, the trial court, is what's called vacated. It's removed. You have to start all over again. Remand means you don't have to start all over again. There's one issue, there's one question that was not given enough attention in the lower court. Maybe damages. Maybe there was not enough information about the damages. Remember, like the man who I was telling you right now, who talked to some doctors and they said he was okay, and other doctors said he suffered injury. So the Court of Appeals is saying, well, some people say this, and many people say that. We need more information. You need to go back to trial on this question, see if this is clear, if he was actually injured. These are the steps once you get into court. So they're going to ask you, these could be, again, multiple choice. They're going to ask you, they're going to mention 3 of these. And then one of them will be the trial. You see, they're going to trick you and say, which one is not the appeals court decision? It's going to stick out like a sore thumb. It's going to be like trial. But the trial is the first step. It's not part of the appeals. See? So 3 of these will be on that multiple choice, and then they're going to ask you which one is not. The 4th one will be like trial. It could be the service of process or ripeness. That's what I'm talking about. When you go to trial, it's important how this works, the steps. This is not a multiple choice question. I'm sorry. This is like a multiple choice question. This is where they're going to give it to you. They're going to mix it up in terms of what goes first. See, what goes first? They're going to put opening statements. One of your choices is going to be like opening statements and then jury selection, examination, like that. So you have to know the sequence. This is one of the harder ones. We have to know the sequence of what goes first. So if you can't remember that, don't spend time don't spend too many, go on to the next question. Because this requires a lot of memory. Sometimes you know what a mnemonic is. A mnemonic means that you get the first letter of each of these and memorize it. So you begin with jury selection. You begin with J, O, E, C, and then J2 is the jury, J2. So you would remember J-O-E, C, J2. And that's how you remember the sequence. That's what's called mnemonic. It's just put it down. It's like a little cheating device to help you remember this. Don't write it down on your hands because you'll be caught. And then you'll be thrown out of the room. So you just memorize it. Okay, elements required for contract. You should, for your own business, contracts is very important for your own business careers. So what is an agreement? So when somebody makes an offer and it's accepted, that's the part you have to have agreement. There's usually an offer or acceptance, except, most business contracts are going to be what's called bilateral contracts. Let me see if we have that. Well, these are what's required in a contract. We'll get to bilateral. You have to have mutual consideration. Remember, something of value. It doesn't have to be equal value. There's something of value or something that one party gives up. Remember like the case where the young man is promised by the uncle if he stops smoking or drinking and he studies, he will give him $5,000. So what the young man gave up was his vices. He gave up smoking and drinking. He didn't. So how much is that worth? Well, the uncle said $5,000. That's the deal. Whatever the parties negotiate, the courts will not look at it to see if it's of equal value. Legal purpose it has to be. Can't be illegal. Subject matter, legal purpose and subject matter has to be proper. So that's one and the same almost. Legal purpose, subject matter. What we're talking about is legality. Legality. Legal capacity, ability to understand the nature of what they're doing. Okay? What are they thinking? What are they thinking? That's what, are they able to understand? That's what I'm saying. Are they able to think? Do they have the right age? That's legal capacity. No minors can be enter into contracts by themselves. Defense to enforcement. This is the defenses this is after you enter into the contract. Say all those things were proper. Now what you have to do, you want to get out of the contract because you find out something was not right with what you bought. So what you're saying is you could have fraud, that somebody committed fraud against you, duress, you were under duress, you were influenced by someone, improperly influenced. So the defenses are important. So what they're going to ask you in the contract is the essay question will be, you have to go through all these steps to show these agreement, mutual consideration, legal purpose, legal capacity. The offer has to be good. It's accepted. It's communicated. The offer is good. Make sure the other side receives the offer. The other side receives acceptance. That has to be communicated. You start off good. You're going through the list, and then you say, well, he finds out something. So then, how can he get out of the contract? With these defenses, he can break the contract, get out. How do we know we have a contract? So today we have, this is also true and false, objective theory of contract, means we look at a situation to see if the parties knew what they were doing. And what the standard we use is the so-called reasonable person. That means, what's the average person who was looking at two people in a restaurant, say in a restaurant, they were talking, they were happy, at the end, they shook hands or whatever, they gave whatever indication that they agree. Then that is what is considered objective. We were looking at it from a third person saying, yes, they did. It looks like they were talking contract and they agreed. So this is what you got to look for. In an objective theory, we have to have these things. If you're going to prove objectively, you have to say, was there intent by objectively that we can measure intent? How do we do that? We look at paper. We look at emails. Okay? We look at text. Did they send text? Did they send emails? Did they bring in definite and certain terms? Were they talking about the same thing? Price, quantity, quality, parties. Say, communication. That they talk. And let's say they didn't put anything down on paper, but they were talking, and you overheard them. You brought in as a witness. And you say, well, they were happy, they were talking. At the end of the long conversation, they shook hands. Those are manifestations of objective that they had a valid offer in a contract. These are the valid offer. You got to have a valid offer to start. That's step one. So the valid offer, you cannot say, well, we had a valid offer. They're going to give you facts, and you have to show those facts in your answer. You have to say, well, they were talking, they communicated, they had sent emails, whatever you can they give you, use that to prove that there's a valid offer. You have to make sure that the valid offer was still good. So the what they're going to do in your test on the essay may be one of the sides decides to change the terms. Then you have a counteroffer. Not a rejection, but it's a counteroffer. And you have to say, under the mirror image rule, you cannot change the terms. You have to accept what's on the table. The other ways would be, how do we cancel an offer? We just say, forget it, when we're talking to someone, or we send them an email saying, I remove my offer. For you, they want you to accept that you reject it. Death or destruction. Again, memorize these, 3 or 4, to get you through. Acceptance. The key thing is silence is generally not acceptance. And that's what the standard is international. Terms of acceptance must be identical. The mirror image rule. So they're going to test you in the mirror image rule. It means that when somebody makes you an offer, you cannot change it. You have to agree with all the terms of the offer. And it's got to be communicated. Anyway, remember that at the bottom. It's got to be communicated. You can do it in person, phone, mail, fax, email. You cannot yet accept by a tweet on Twitter. It's a little hard. The mailbox rule. The reason on the Twitter is you got limited number of characters. It might not be clear acceptance. It may be vague. Mailbox rule. Acceptance by mail effective when placed in mailbox. So the mailbox rule means that if you put your answer in the mail, in the post office, at that very second, it becomes an acceptance and it cannot be canceled. You've accepted, and they have to accept your acceptance. However, if the verification of the offer is effective only when received by the offeree, so the offer cannot be canceled on you if the offeror puts it in the mail. He calls you and you put your acceptance in the mail, and then the next day he sends you a cancellation, a verification. But you don't get that for 3 days. It's too bad. You have already accepted the offer, and it's a violation. If everything else is fine. Mailbox, you gotta know that. Remember, consideration is give something of value. Doesn't have to be equal value. This is a true and false. Question, requirement contract means the buyer agrees to purchase all goods. The buyer. Output means the seller agrees to provide all products to a buyer. Remember, they're going to mix it up, and that's where they try to trick you in a true and false. So requirement, buyer requirement, seller output. Buyer requirement, seller output. Liquidated, unliquidated. Liquidated, no dispute. Unliquidated means the parties dispute in good faith the amount due. Liquidated, no dispute. Unliquidated, dispute. Remember, contractual capacity, mental ability to understand. They're going to ask you about minors. They might bring that in a short question, short essay. Is the parent liable? No. for minors entering into contracts. They're going to say the minor got some medical help. And then you have to say both. You have to say the general rule is they're not liable. Exception here is medical necessaries. That's what they're going to give you, that kind of example. But you have to say first the general rule. General rule for torts. Remember, this is where the child throws a ball at someone who's walking by. He hits him in the head very hard. Baseball. And so now, he's got to do this. He, the parent, has to pay because he did not supervise the child properly. He should have realized that throwing the ball into the street could hurt someone, hit somebody. Legal assent means you are able to enter. You have to have no mistake, no misrepresentation, nothing like that. It's got to be perfect what you're accepting. Understood. Mistake is when one side or both sides make a mistake. If one side makes a mistake, it's too bad. So, especially for merchants, we're dealing with merchants. It's too bad. They should know what they're doing as a merchant. Mutual mistake by merchants, it gives them the right to cancel. But usually what they do is accept the good and try and sell it if they can. Even though it's the wrong good, they still try and sell it. Okay, this is what I want you to review for Wednesday. 33, 34, 35, 36, 37, 38, 39, 40. Nothing at no 42 forward. Any short Q&A? I know it's a lot, but you got to know this stuff. Great. Okay, look at the PowerPoint. It's that I have for Wednesday.